Hello, good afternoon, everybody. You're very welcome to our joint webinar between the Housing Agency and the Residential Tenancies Board. Hope you're all keeping well. David Rouse is my name, advisor with the Housing Agency, and we're broadcasting to you, if you like, from Dublin today. And it's a very sunny day in Dublin. So hope things are well and good where you are. We are going to start our webinar proper in a number of minutes. We have a lot of people joining us. We have a very diverse audience here this afternoon. So what I'm going to do while people are logging in is launch a little poll, which you might let us know your involvement in the sector. This is an anonymous poll, so feel free, please, to populate it. All we're asking is just for you to indicate your involvement in the letting and managed estate sector. So, are you a private landlord? Are you a tenant or a renter? Are you from an approved housing body? Are you a member of local authority personnel or staff in the legal profession, the property services provider, or other? So, as I say, it's an anonymous poll, so please do feel free to let us know, and I'll let that run a little bit for another 20 seconds or so. So we're joined this afternoon by Emer Morrissey from the RTB, and I'll introduce Emer more formally in a couple of minutes, and we'll go through some housekeeping and procedures for ease of running of the event and to make it engaging for all of you. So I've run that poll now for just about a minute, and I'll finish that up. And so thank you very much indeed for sharing that with us, and that's very helpful indeed. I'll just share the results of that on screen, so you should be able to see the survey in relation to breakdown of attendees here today. So again, thank you very much for your time in attending with us, and we hope you find the session of value. So I'll just close that poll result there, and I will start sharing my screen again, and we'll go through some housekeeping for today's session. We will aim to keep to time and respect your time. And again, thank you for joining us today. So we'll aim to do some introductions, and I'll do a little bit of background, if you like, and an update on what's happening in the managed estate sector over the last number of months. Many of you may have been on previous webinars that the Housing Agency delivered, and you will have seen how we try to share information around the sector. Then I'll do a presentation, a short presentation on the MUD Act and its relevance to the landlord and tenant relationship in managed estates. Then we'll hand over to Emer for her presentation on the dispute resolution side and the role of the RTB, and then we'll have some time for Q&A. Now, we have a huge audience here this afternoon, and we'll do our best to answer the questions. We have about a dozen questions, 10 or a dozen questions that have come in already, so we'll try and address those in the Q&A, and we'll also try and get to your questions as we go through. So you'll be familiar, most of you now, with the Zoom platform at this stage, and you know that there is a Q&A function. So if you hover over the bottom of your screen, you'll be able to type your question into the question box there, and we'd be grateful if you do that. If you could please use the chat function for any problems. So if there's difficulties with sound, or for example, one of the speakers can't be heard, or you're having a difficulty in that respect, use the Q&A, rather use the chat function for technical problems, if you like. And my colleagues, Tara Doyle and Sarah Kennedy, are helping me in the background on the technology side, so they'll be able to flag any difficulties there. And thanks to Sarah and Tara for their help. And indeed, we have Andrea with us from the RTB as well, so we're very grateful to Andrea for her time and assistance, and that of her colleagues in the RTB. The event is being recorded for future use, so we'll make it available to you all, and you can look at it in your own time if you want to maybe go over some of the points that we've raised, or look at the slides again. We should preface the remarks we make by saying that the information, of course, we're providing today is general in nature. It's not meant to be legal advice in any form, nor indeed is it specific to any particular case. So there are mechanisms from a dispute resolution point of view with the RTB, and if you have other queries, you should get specific advice dealing with the circumstances and individual features or characteristics of a particular case. Please send us an email to mud@housingagency.ie if you've queries, and indeed we will send out slides. Actually, there's no need to email us in for a copy of the slides. We'll send them out. We'll compress them in size and we'll send them out to you. So that's just some housekeeping. To remind you, of course, we all know what's dominating our lives, unfortunately, at the moment, and it's just a reminder where you may obtain information on the COVID situation. We are at level 5, as you know, and the information is available on the gov.ie website. So we'd encourage you to access that, and we'll talk a little bit more about some of the relevant information for this particular sector that's available online. A little bit about the housing agency. We work with the Department of Housing, Local Government and Heritage, with local authorities, with other state bodies like the RTB, with approved housing bodies and other stakeholders in the sector. And our mission, if you like, is to promote the building of sustainable communities, and our involvement from this perspective in transmitting information on the managed estate sector is recognition of the importance of owners management companies in the housing stock, be it apartments or conventional housing. And our website, of course, is housingagency.ie. And so our presenters, myself, some information about me, and as I say, delighted to have Emer Morrissey from the RTB, and Emer is the head of dispute resolution with the RTB for the last year or so, and she's worked in the housing sector for in around 15 years, is a graduate of UCD and holds a master's in social policy and a Bachelor of Social Science. So we're delighted and looking forward to hearing from Emer very shortly. So thanks indeed to Emer. So what's new for the apartments and managed estate sector? I'll give you a quick rundown on some new statistics, some information that's come through from the PSRA, a little touch on COVID-19 and essential services, a quick mention of the new Companies Act, and a mention of CRO filing extensions in the context of owners management companies. So this is information that was released, I think the week before last, from the CSO, just around 2019 and what has happened in the housing sector, and particularly in relation to apartments in that period. So in 2019, for the first time, more apartments than houses were granted planning permission. Permissions for 20,582 apartments were granted in 2019, as against about 9,000 in 2018. So a huge increase, 125%. But amazingly, the number of apartments granted planning permission is still lower than the peak of about 32,000 granted in 2004. So interesting to see where we are and where we've come from. Over the period from 2010 to 2019, the number of apartments granted planning permission was up by almost 200%. Now, in terms of completions, about 3,500 apartments were completed in 2019, and that was up by about 56% on the 2,200 completed in 2018. And of the completions in the Dublin area, there's a quick breakdown of how they settle in terms of apartments and conventional houses. And of all the apartments in the country, 73% of those completed were in Dublin in 2019. And some stats just from the CSO, you can see bearing out the analysis, or the last slide, just in terms of the apartments versus houses. You can see in the red box at the end, where apartments, which is the green bar, if you like, on the graph, exceeded or outpaced houses as a housing type granted planning permission. The Office of the Planning Regulator published their annual report last week for 2019, and they have some interesting statistics on who is granting, or what planning body is granting permission for apartments. And you see the last set of bars on the graph in the red box. You can see that strategic housing developments granted permission by An Bord Pleanála are far outpacing apartments granted planning permission by local authorities. And equally, where by region are apartments and houses been granted planning permission, and you can see in the red box in the Eastern Midlands Regional Authority, which is basically the Greater Dublin and parts of Leinster area, apartments have far outpaced houses in terms of permissions granted. And equally in the Dublin area, so this is where our permission's been granted by city region, if you like, and you can see hugely how our apartments outpace houses in the Dublin area. And this is, I think, my last or second last slide on statistics, really, just to show the green line at the end. You can see how far completions in terms of apartments have outpaced or where apartments are rising up to meet single schemes and other dwellings by type over the period 2011 to 2019. So interesting to see. Some material again, just by way of background, what's coming out in the sector. The Property Services Regulator, IPAV, and the SCSI have prepared a guide to the COVID plan. And what's interesting there is they have some useful tables, basically setting out the particular services that can be provided at the various levels of the COVID plan across the country in terms of the letting of land or in terms of property management services. So that guide is available from the PSRA website and equally from the two professional bodies. I refer to the gov.ie website, and that sets out what are essential services. And we've put on one slide all the, I suppose, references or contexts where services in relation to residential property and let property and managed estates might fall in. So you can go online and you can check that out. And we would say again that this information is for participants in the sector to interpret themselves, but the guidance is set out there on the gov.ie website. Our own publication with the SCSI and IPAV, guidance for multi-unit developments and residential owners management companies, that's available online on our website, and it really is information on how to or information and suggestions on how to manage residential estates and OMCs and multi-unit developments in the context of the pandemic. So useful hints and tips there. Many of you will know that there was a new Companies Act passed earlier in the year, which really allows for owners management companies to have online virtual annual general meetings, and it allows voting online, and that facility applies up until the end of this year. It may be extended. There's provision in the legislation for extension, but that'll be a matter for the government to decide. But it is a very helpful piece of legislation that allows management companies to set their budgets and elect their directors and set their house rules and so on and so forth. So that's available to you as well. Just the Companies Office, the CRO, keep an eye on their website if you're responsible for filing the annual return for an owner's management company. They frequently update their website with information for company secretaries and directors and accountants and solicitors who are dealing with all that, and indeed the OMC directors themselves. So that's worth looking up. The Waste Action Plan was published a number of weeks ago, and there are some specific measures intended for the managed estate and multi-unit development sector, and I've set some of those out for you there. We've extracted the statements of intent, if you like, from the Department of Environment and Climate Action, and there are intentions to change, I suppose, the waste management systems applicable to apartment developments and managed estates to try and encourage and improve waste segregation in apartment complexes. And there are various schemes and best practices planned by the departments there. So I suppose it's a case of watching to see what emerges through that. Our own report published on our website, Apartment Living in Ireland 2019, has some interesting statistics and analysis of attitudes and perceptions towards, for example, property management, management services, the standards in common areas, people's likelihood to become directors of owners management companies. So I'm not going to go into all that. That's available. You can check out our website. That's where it is online, and we encourage you to maybe have a look at that if you wish to do so. So coming on to my presentation, that's a summary of what's going on in the sector, if you like, and the main developments at the moment. So coming on to the specifics of what I'd like to address before we hand over to Emer is really, what do we mean by managed estates? We're not restricting ourselves here, I suppose, to apartments. Managed estates can mean conventional houses with common areas that are shared between the residents. It can mean mixed-use developments where there's residential residential property, so family homes or homes, with commercial properties. It could be shops or offices mixed in with the particular development. So it's important to set the scene and say what we mean by managed estates. We're not, as I say, we're not simply restricted to apartment blocks. And equally, within apartments themselves, there can be the conventional, if you like, what might be called build to sell, where there are multiple owners of apartments within the development. Or more recently, we now have the private rental sector, or PRS, which is a conventional build type, if you like. So the same as the traditional apartment build, but where there's one owner that rents all the apartments out to different tenants. And then finally, the other type of apartment development that we're seeing now is the build to rent, or BTR type of development, which is purpose built. So the common areas and the apartment types are built specifically with the build to rent sector in mind, and there is again one owner of that particular apartment block renting out the properties to various tenants. So again, just to keep in your minds that there is a much more complex landscape, if you like, and a much more diverse type of apartments out there in the country compared to what would have been the case maybe even 20 years ago. A useful publication, and I'll just stop sharing my slides for the moment, is a book called The Policies and Practices of Apartment Living, and it's by Professor Hazel Easthope, who is a professor in, would you believe, Sydney, in the University of New South Wales, and she has taught a lot and written a lot about apartment developments and living in managed estates. And I suppose what she has focused on is that a lot of the relationships and a lot of the tensions, and we'll have to acknowledge that there are tensions in managed estates, are derived from the balance between collective rights and individual rights. So collective rights around management of common areas, or collective rights around various facilities and contributions to service charges and all the rest of it, versus individual rights, people's right to the quiet enjoyment of their home, and the right to park where they're licensed to park, and so on and so forth. So it's really about the balance around all those rights. And she has identified, I suppose, three key features that are unique to managed estates as opposed to people living in homes that are not, if you like, intertwined in conventional housing. And the three factors she has identified are proximity. So in an apartment, you could have someone above you, below you, and either side of you. There's that interdependence aspect. The second particular unique feature of managed estates, where people, whether they like it or not, they rely on each other. And as we've seen much more the case since February, certainly there's an interdependence and a reliance by residents in terms of coming together, and maybe in a residents association, or equally in an owners management company on the formal corporate level, where they have to work together, and they rely on each other to make progress in an estate. And the final unique feature that Hazel identified was the joint decision making that's involved in managed estates. So again, through the forum of the owners management company in most cases, that the residents elect directors to make decisions on a collective level for the benefit of all the members in the estate. So those are useful, I think, useful thoughts to have in our minds again when we're thinking about the managed estate scenario. And that's a very interesting publication, but just useful to crystallize those thoughts. So this is a very complicated particular diagram that I've used in past presentations, and really, I suppose, this tries to set out all the relationships in a managed estate and the who's who, if you like, because it's important to deliver clarity on who is who and who is responsible for what particular rights and duties in an estate. We're focused today on the red box on the left, so the relationships between landlords and tenants, be they institutional or private, and public as well. Now, conscious, obviously, the RTB are speaking on residential tenancies, and it's important to point out that local authority tenancies are outside the remit of the RTB. The courts still deal with those, but Emer can touch on that in her presentation. But you know, it's useful just to have that, and you can look at the slides later on. As I say, we'll send them out to you, and to think about the different relationships in the managed estate, and to understand the particular players in the dramatis personae, if you want to use that term, in the play. And at the core of it all, of course, in a managed estate is the OMC, the Owners Management Company. And some of you who've been on our presentations before will have seen this particular slide where we've tried to articulate that an owners management company is really a hybrid entity. So it's a combination of a residents association, because the directors are volunteers, a not-for-profit. 99% of owners management companies are companies limited by guarantee, and so they're there to collect service charges and pay for services. So they're not there to make a profit, but ultimately they are a property management or an asset management business, so they have a responsibility in that respect. So it's useful to bear that in mind, and the nature of the OMC and how that works in a managed estate. In terms of rights, duties, and obligations in a managed estate, the main document really where these rights and duties are found is in the head lease, which is entered into between the owner's management company, the property owner, and the developer. And that's an example of a head lease. And I'm not going to go through all that, but really the head lease is important because it defines the common areas, it defines the estate service charge, it defines the demise of the individual properties, and it's a very important document that sets out the rights and duties in a managed estate. And for example, those are just two clauses from a typical head lease. That number 8, the property must be used for residential purposes and not for any other purpose. And number 9, noise isn't permitted outside the property, say from 12 to 9. So just to give you a flavour, again, we could go into a lot of this in detail, and indeed we have in some of our earlier webinars, which are available to you on our website, and we'll flash up the page later on. So just to quickly touch then on aspects of the Multi-Unit Developments Act 2011 that applied to the managed estate sector, to focus on 3 specific areas where there is, if you like, an engagement in the landlord-tenant relationship, or there's a reference to the landlord-tenant relationship. The first is under Section 8, subsection 3 of the legislation, and that really sets out what an owner, so in this case a landlord, must provide to the owner's management company. Obviously, he must provide his own name and address, but the owner's management company must receive details of the tenants in the unit, and perhaps any other habitual occupants, so lodgers and so on and so forth. That's worth remembering, I suppose, in the context of if you like, emergency situations in an estate. If there's a leak or a fire or a difficulty where the tenants need to be contacted urgently at short notice, you can see the logic for that. So that's just to touch on one aspect of the MUD Act, where there's an interaction with tenants, if you like, and landlords. The next one then is an obscure enough subsection in Section 18 of the Act, which says that if the tenant and the landlord so agree, it is possible for a landlord to pass on the obligation to pay service charges to the tenant, but that obviously must be by agreement between the landlord and the tenant under a sublease. And I know Emer has a case study on that she'll touch on, so I won't dwell on that too long. It's a very rare thing, if you like, but the possibility is there. The next one then really is quite important. It's in relation to the house rules, and those house rules are governed by Section 23 of the Multi-Unit Development Act 2011. And the house rules are binding on all unit owners, so landlords or indeed owner occupiers. They're binding on tenants of unit owners, and they're binding on servants, agents, and licensees of persons referred to in A and B. So anyone who is associated, if you like, in the context of the property with the unit owner and the tenant. Subsection 2 of Section 23 says that the house rules must be consistent with the covenants and conditions of the head lease and of any other leases. So essentially, the impetus or the purpose behind the house rules is really to provide for the quiet enjoyment of individuals' property, be they tenants, be they owner occupiers. So that the house rules are an important part of the relationships between landlords and tenants in managed estates. And it should be a term of every letting under subsection 10 of section 23. It's a term of every letting of a unit in a multi-unit development that the letting is subject to observance by the tenants of the conditions in the lease and of the house rules. So it's worth bearing that in mind from a landlord and a tenant point of view. And equally, we have on our website a sample set of house rules for a managed estate. It's a Word document, and you're more than welcome to download it and to look at it. And for maybe directors of owners management companies, if they're looking at modifying their own house rules, they can maybe take a lead from that. But obviously, they need to probably take legal advice in the context of their own head lease and so on. But that might be useful to you as well. One interesting part of the legislation is section 23, subsection 11, which allows an owner's management company to recover the costs of breaches of house rules in a managed estate. So there is that facility that, for example, if a landlord has a situation where perhaps a tenant is driving costs for the owner's management company in dealing with breaches of house rules, the OMC can levy that cost back onto the landlord. A quick mention of some recent case law in the courts last year was Kennedy versus Sweepstakes Owners Management Company, and really I've done one slide on a synopsis of that case. Mr. Kennedy was a tenant in a multi-unit development. He claimed that the owner's management company was seeking to implement house rules which were in breach of law. Now, tenants are not listed in Section 25 of the MUD Act as people who may apply for relief or who may, for example, challenge the house rules in a multi-unit development. But there is a subsection 1F in Section 25 that says that with the permission of the court, other persons, as the court may see fit, may apply to seek relief under Section 24 of the Act. In other words, they could perhaps challenge the house rules. And so the question was, could Mr. Kennedy, the tenant, bring an action under the MUD Act? And the court said yes, where they could see no rational basis for the denial of the relief, and where the grievance in question seemed to be reasonable and had no other avenue, if you like, of address, then the court would not refuse the right to the tenant to bring an action under the MUD Act. Now, what happened in that case, we don't know, because the MUD Act actions, that was a High Court case, but the MUD Act is under the jurisdiction, the actual implementation of the MUD Act is under the Circuit Court, and most Circuit Court decisions aren't reported. So maybe there are lots of solicitors engaged on this session, so maybe if any of them have seen how that case wound out, they're more than welcome to contact us and let us know. So what I've done really on that slide is try and really capture, if you like, the flow of responsibilities and duties as between the different parties in the estate. So we have the head lease on the left. The head lease applies to the owner or the landlord, and the owner or the landlord can then issue a sublease, which must be subject to the head lease. Equally, the OMC and the owner as a member of the OMC develop the house rules, and the house rules apply to owners, landlords, the house rules apply to tenants, and the house rules apply to the sublease as well. So again, it's just one way of trying to encapsulate it on one particular page. And I suppose if we were to kind of think about relationships and the dynamics in owners management companies and managed estates, that's the one thing that I would emphasize. Good old RESPECT, respect. If people have respect in terms of the relationships, be they tenants, be they owner occupiers, be they landlords, be they commercial, be they residential, that will be a very firm starting point in dealing with the other relationships and tensions and balance of responsibilities that we mentioned earlier. So hopefully that's useful in that context. I have a couple of last slides before I hand over to Emer. A quick couple of points on managed estates and other issues. So if it's a question of the owner's management company failing to comply with company law, if there's a difficulty there, that's a matter for the Office of the Director of Corporate Enforcement. They're charged with the responsibility for seeking compliance and enforcing company law. And they have a document that they've developed, I have it up on screen there, that's available on their website, about what issues in owners management companies they will address. If there are problems in relation to the management agent, so the business that has been employed, the agent that has been employed by the owner's management company, because it's important to draw that distinction between the OMC and the management agent. If there's a problem with the agent, it could be between the agent and the OMC, then it's a matter for the Property Services Regulator, and they have lots of information and details on their website that you can look at. In terms of ourselves, we have other resources available online. You can check it out on our website. We have a particular page that has been drawn together with all of the most recent webinars that we've hosted, and they should be available to you to watch back, as indeed will this one in due course. Any queries, you can contact ourselves, mud@housingagency.ie, and I know that was a whistle-stop tour, if you like, but I'll stop sharing my screen now, and hopefully I will ask Emer maybe to turn on her camera and her mic. Hopefully, Emer, you can hear us okay, and I'll hand over to you for your session. So we're delighted to have Emer with us, and thank you very much.
Thanks, David. Thanks everyone for joining us today. I'll just see if I can share my screen now, hopefully. Okay, so hopefully everybody can see that. So I'm going to take you through today basically a little bit about the RTB, and then bits about rights and responsibilities for tenants and for landlords, and then specific aspects of if you're letting and living in apartments and managed estates. So, and then we'll talk a little bit about ending a tenancy, and just there's been a lot of legislative change since March, since we came into living with COVID, I suppose. So I'm just going to give you a really brief overview of that, because it is quite detailed, and a little bit about the dispute resolution service. So a little bit like David, mine's going to be a bit of a whistle-stop tour of the RTB, but we have really good resources available on our website. We have a web chat facility as well, so you can get on and you can ask questions to our agents down there who can provide information. But there's great resources for landlords and for tenants available on the website, and there is we've templates, and we've a lot of information on the emergency legislation as well. So please go and check that out if you have questions after this. So just a little bit about the RTB. So we were established in 2004. We are one of the only housing regulators in Europe. Our aim is to provide an effectively regulated residential rental sector that's fair, accessible and beneficial to all. In the RTB, we have 5 main areas. So we have dispute resolution service, which is my area. We've got tenancy registration, where all tenancies must be registered. We've also got investigations and sanctions, which is our newest kind of section, which is, I suppose, a little bit further on to dispute resolution, where there are breaches in setting an RPZ, setting rent in RPZ and that kind of thing. We also do a huge amount of things like this, which is information, education and awareness. And we have research and the rent index, which is quarterly rent index that we publish. So just to say, we do, David mentioned there, I suppose, what comes under our remit. So we do look after all residential tenancies, including AHBs, but we don't deal with local authority housing. And there's a couple of things that don't come under our remit. So one is holiday lets, so that's any short-term lets that are purposely for holidays. The rent a room scheme, that's where somebody's renting out a room in their own property. So if you're sharing your dwelling with a landlord, it doesn't come under our remit. And also if you're living with the spouse, civil partner, the parent or child of a landlord as well, and there's no written lease in place, that doesn't come under our remit. And just a few stats there really quickly about us, just so you can kind of see the size of the sector that we're dealing with. So in 2019, there were over 360,000 tenancies registered with the RTB. Over 32,000 of them were approved housing body tenancies, and over 28,000 were student-specific accommodation. So student-specific accommodation only came into us in mid-2019, I think, under new legislation. So that's an ongoing piece of work, bringing those accommodation types on board and getting them registered. And of our registrations, we have 169,960 landlords registered. So as you can see from those numbers, some landlords would have multiple properties and some would be single property landlords as well. And in our call centre and in our contact centre, really, so we have web chat, we have calls, we answer emails. And in total last year, we had nearly 300,000 total customer contacts with people. So it's very busy down there, really taking queries from people, but it's a really good service if you have a quick question that you just want to get an answer from. So I'm going to take you really quickly just through the rights and responsibilities of tenants and landlords. So we have a really good guide, the landlord tenant guide, which is available on our website. So it kind of goes through all of all of the rights and responsibilities of a landlord and a tenant, and it goes out as well with registration, so it should be available on the website for anybody looking for it. So as a tenant, what am I entitled to? So one of the things is that the property is in good condition, and I'll go through the minimum standards soon enough. You're entitled to privacy, so that's peaceful and exclusive occupation. So that means that your landlord can't just, I suppose, drop in unannounced, that they have to make an appointment. And I think the thing to remember is when you rent a property, that's your home, it's where you live. You know, you have to feel safe and secure in it. So it's important as a landlord that you are making appointments and you're letting people know if you're coming over and it's for specific reasons. You're entitled to have a rent book or a written contract or a lease as well. Really, that's just to outline all of the points, the main points of your tenancy agreement, and where Dave just mentioned as well, the house rules, those kind of things should be included in that. You should be told about any increase in rent in writing. There's specific rules around increasing your rent, whether you're in a rent pressure zone or you're not in a rent pressure zone. Certain things have to be followed through for increasing your rent, and there's more information about that on our website. You should be able to contact your landlord or their agent. So it's really important that you get contact details for your landlord, and even if you're renting through an agency, that you know who the landlord is, who the actual property owner is. So that's really important that you get that as a tenant. Your right is to be paid back any money from the landlord where repairs are required. So this is where if something breaks in a tenancy, it is your responsibility to tell the landlord that it's broken and give the landlord a reasonable amount of time to get it fixed. But if something happens and they can't get it fixed and you come to an agreement that you will get it fixed, you're entitled to get that money back from the landlord. And you're also entitled to get a valid notice of termination. So again, the notice of termination, I'll go through this a little bit later on in slides, but they are prescribed. There's a certain way they have to be issued. There's certain things that have to be on them, and you can get templates of them on our website as well. So you should go along and have a look at that. So responsibilities, what's expected of you as a tenant. So you're expected to pay your rent in full and on time. We'd always encourage people, if you're having any difficulty paying rent, get in touch with your landlord as quick as possible and see, you know, can you come to an agreement about it if it's only a short-term thing. But communication is really, really key within the tenancy, that any issues that are going on, you really should be communicating with the landlord, and vice versa, the landlord communicating with the tenant. It's your responsibility to keep the property in good order. So, you know, if things are broken or if there's any maintenance issues or anything like that, that you let the landlord know, that you allow the landlord to carry out inspections of the property. So again, this should be pre-arranged, and sometimes this is in the lease. It might say that they're going to do an inspection every 6 months or every quarter or something like that. Letting the landlord know who's living in the property. So if you move somebody in with you, or if you're moving out and you're going to sublet, you need to get the landlord's permission for that. Not engaging in antisocial behaviour. So this doesn't, I suppose, just involve the tenants. This is anybody that the tenant allows to come to the property, or that the tenant allows to be living in the property as well. So they have to make sure that those people aren't involving in antisocial behaviour. And then complying with the terms of the tenancy agreement. So these are things that are laid out in the tenancy agreement, and they might be part of the house rules. So it could be that you can't dry laundry out the window, that, you know, the bins have to go in a specific place, that you can't leave items lying around in the communal areas, and all these should be outlined in the lease between the landlord and the tenant. And other things that are expected of me. So if you're ending the tenancy as a tenant, you have a certain amount of notice that you have to give. Again, this is available on our website, because it depends how long you've been living in the property. You should keep a record of any repairs and payments and dealing with the landlord, because again, I suppose if this comes up as part of a dispute, or if you're owed money back, you need to be able to show that you have paid that money. And to ensure that you don't do anything that could affect the insurance of the property. So I suppose that's not to be engaging in anything like, I suppose, manufacturing anything in the property, or doing anything that's going to make damage to the property, or any serious antisocial behaviour. And as a landlord, rights and responsibilities. So as a landlord, you're entitled to set the property in the rent and receive the rent in full. So again, like I mentioned, there are certain rules about setting the rent, and information is available on our website about that. A landlord can end a tenancy within the first 6 months without giving a reason. They have to give notice before the end of the 6 months though. The landlord's to be informed who's living in the property. They're to be informed of any repairs that need to be given, and to be given a reasonable time and reasonable access to fix them. Again, the landlord can schedule an inspection of the property, and this should be done in conjunction with the tenants, and making sure that there is communication going on around that. And the landlords had the right to not have the dwelling altered or improved without written consent. So that can even be things like painting the property. You know, some landlords may not want the colour scheme changed or any bold colours or that done, or if it's altering, even putting down carpets, things like that. You should really have a conversation with the landlord. And I think the main thing is, for us in the RTB, is communication really is the key thing to a successful tenancy. So if you're in doubt about something, have a chat to your landlord or have a chat to your tenant and see can you figure it out. You know, really is the best way to keep things going steadily in the tenancy. As a landlord, you're responsible to, again, allow the tenant peaceful and exclusive occupation. This is their home, and you shouldn't be turning up unannounced. You should be providing the tenant with contact details and a rent book or a lease, a receipts of payment. So if the payments are done electronically and you can see it coming into bank account, that's a good way. But if it's any kind of cash payments, you should be providing receipts. All tenancies must be registered with the RTB and must be done so within 1 month of commencement of the tenancy. And again, all repairs should be carried out, you know, within good time. And I suppose both tenants and landlords have to be reasonable around times of getting work people to come to the house to carry out any repairs and to return the deposit promptly. So obviously there are reasons sometimes for people to keep a deposit, but make sure that if you feel that you need to keep any of the deposit, that it's well documented and that it's explained to the tenants why this is happening. You're also expected to make reasonable effort to enforce the tenant's obligations when a third party makes a complaint. So this can be something that comes up, I suppose, a good bit in managed estates and in, say, apartment blocks, where the tenants may be causing problems for the neighbours, and the neighbours are actually allowed to bring a complaint to the RTB as a third party. But before they do that, though, they need to address the issue with the landlord, and the landlord has to address the issue with the tenant. So this could be antisocial behaviour. Again, it could be like leaving things out in communal areas. It could be just noise coming from the apartment at you know, unreasonable times. So landlord's responsibility as well to give the tenant written notice of termination. Again, templates are on our website and there's really clear instructions about notice periods and those kind of things. And some things have changed in the last kind of 6 months with new legislation as well. So it's important to go onto the website and have a look at that. And again, return any deposit. So just for minimum standards, I'm not really going to go into this too much because it's really regulated by the local authorities, but there are minimum standards for rented properties. We have a really good leaflet there that's available on our website about it. If you feel like there is problems with minimum standards and the landlord isn't dealing with them, if you report them to a landlord but they're not being dealt with, you could bring a case for breach of landlord obligations, because it is the landlord's obligation that he just maintain the property. But if there's serious things that aren't being fixed, the local authority can come out and do an inspection and they can actually enforce that the things are fixed in the property. So just at renting an apartment estate, there's a few things that are, I suppose, slightly different than if you were renting in a single unit. So the responsibilities in managed properties, the landlord is responsible to maintain the rental property, so the actual apartment or house that they own, but often the management company is responsible for the communal areas. So that might be the lifts and the car park, the bins, those kind of things. And so they can be specific to, say, cleaning the communal areas, maintaining things, making sure there's car park spaces, access points, communal fire alarms, those sort of things. The relationship between the landlord is between the landlord and the management company. So the tenant really should be telling their concerns to the landlord, and then the landlord is responsible for addressing those with the owner's management company. And vice versa as well. If there's issues with the tenants that are coming to the attention of the management company, they need to go to the landlord who addresses it with the tenant. And the Residential Tenancies Act specifically, I suppose, calls this out in section 12(1)(h), where it requires the landlord to forward any complaints made by the tenants concerning the performance of the owner's management company to them, and they are required to put it in writing and ask for a response, and when they get a response, to provide that to the tenants. If the landlord fails to address the tenants' issues with the company, then this can be seen as a breach of obligations by the landlord. So I just have a case study in there around this. So this is a case that we had brought into the RTB where the tenants brought a case for breach of landlord obligations because they felt that the landlord had breached his obligations because he attempted to increase a fee for a parking space to €200 a month. So the tenants have been living there for a number of years and they'd paid €7 a year always to the management company for the parking permits. The landlord contacted them and said that he was increasing the fee to €200. And he stated that this was an increased fee that the owners management company were bringing in, and that he was just passing it on to the tenants. So the tenants requested to get information from the owners management company to see proof of this, but the landlord wouldn't consent to that information being passed along. And the adjudicator found that the landlord couldn't provide any proof that this was an increase from the owners management company, so that he was in breach of his obligations to try and increase the additional charge and to put it onto the tenants, because it hadn't been stated in the original lease. And like David mentioned, they have to be done in agreement. And this is another case study just around communal facilities. So this is a dwelling that was located in an apartment block. The tenant brought a case for breach of landlord obligations as there were problems with the intercom and the lift. The tenants had been in communication with the landlord numerous times over a year about these issues. The landlord stated that he was aware of it and he had passed the complaints on to the owners management company, and it wasn't being addressed, but he was going to bring it up at the next AGM, which is coming up. The adjudicator deemed that there wasn't a breach of obligations because the landlord had done everything to address this issue with the owners management company, was continuing to do so. So the landlord had actually complied with his obligations and there wasn't any breach. And because the landlord really has no control over the communal facilities except to keep addressing the issue with the owners management company. So just quickly around ending a tenancy. So some people might call this ending a Part 4 tenancy. So a tenancy becomes a Part 4 tenancy when you've been living in it for over 6 months. So you gain additional security. So like I said previously, before 6 months, the landlord can issue a notice of termination without giving a reason. But once it goes over 6 months, there are 6 reasons stated in the Act that landlord can serve a notice of termination. So that's what I just said there. Yeah. So the notice of terminations, they have to be in writing. They can't be served via email or text message or a phone call. They have to be in writing and they have to be either posted to the tenant or handed to the tenant. It's good to have evidence of sending the notice of termination, so that if it is queried, that you can show that you did send it on a certain time and date. There's certain things that have to be in the notice of termination. So it must be signed, it must have the date it was served, has to specify the date the tenancy must end, and that must be in line with the termination periods that are stated in the Residential Tenancies Act. It has to have information depending on the type of notice that's being served. So I'll go through those in a second. So once the party receives the notice of termination, if the tenant believes that it's not a valid notice of termination, they have 28 days to bring a case to the RTB. And again, there's templates available on our website around notice of termination. So the 6 reasons for ending a Part 4 tenancy. So one is breach of obligations. So if there's a breach of obligations, the landlord can serve a 28-day notice of termination. However, new legislation that came in August makes some changes to this if it's around rent arrears, and the rent arrears are specifically linked to COVID. So I'll briefly go through them towards the end. Another reason, if the dwelling is no longer suitable for the needs of the people living in it. If the landlord intends to sell the property within 9 months of termination of tenancy, this also requires that they have to provide a signed and witnessed statutory declaration to show that they are intending to sell. If the landlord requires the property for their own use or for a family member's occupation as well, and again, they need to provide a statutory declaration. If they plan to substantially refurbish or renovate the dwelling, and again, they have to provide a statement of the works, and it's quite a high standard there for the works for a substantial refurbishment. And then the last one is if the landlord intends to change the use of the dwelling. So I suppose if it goes from being a residential unit to being a commercial unit, but again, they have to provide a statement of works for that. So one thing that just is different if you're living in, I suppose, a block of apartments is that we recently saw something come in which is called the Tyrrellstown Amendment. So people may be familiar with this. So this is where if a landlord aims to serve a notice of termination in where he's selling more than 10 units in one development. So prior to this, I suppose landlords could serve on an entire block of apartments to sell them and to have them sold as vacant possession. But after a developer tried to do this in Tyrrellstown, and this Tyrrellstown Amendment was brought in to protect tenants in these units. So in order to be allowed to sell for 10 or more units, the landlord has to prove a couple of things. So it's a fairly high burden of proof the landlord has to provide for this. So they have to show that they need to sell the properties vacant, and if they sold them with existing tenants, they wouldn't be able to achieve 20% below the market value. So they really have to show that they'd be at a loss of 20% if the tenants were in situ. And they also have to show that restricting the sale, so not allowing the sale to go ahead, would be unduly onerous on the landlord or would cause the landlord undue hardship. So it is quite a high standard for the landlords to have to meet to sell this. So just a case study from a Town Amendment case we had. The landlord served a notice of termination for sale on 14 properties in the same block. They did claim that they could sell the apartment block if it was empty for 20% higher than if the tenants were in situ. And to prove it for the case, the landlord brought in an expert witness who claimed that the difference could be between 28 and 41%, depending on the property type, because some were 1 beds and some were 2 beds. However, the adjudicator found that the landlord couldn't prove the second part, which is that they would suffer undue hardship if they sold the properties in smaller batches, and so the notice of termination was invalid. So they're not saying that they can't sell the properties, but just that they can't sell them all 14 in one go with sitting tenants. So it's trying to encourage people to sell properties with tenants in situ. So just going to really quickly just run through the new legislation. There's 3 pieces of legislation brought in during this crisis. So the first one was the Emergency Measures and Public Interest Act. This was introduced in March 2020. The idea of this was really, it was around a health measure. So it was to reduce people from moving around. And because I suppose an awful lot of people were working from home, a lot of estate agents that were closed. So it was very hard for people to find new places to rent. So this legislation bans the ending of tenancy or any rent increases during the emergency period. It originally was supposed to be for a period of 3 months, but it was extended until August 1st. So that meant between March 27th and August 1st, tenancies couldn't be ended, and if you had served a notice of termination, it was paused for that period. So if you'd served a notice of termination and there were 10 days left on the 27th of March when it came in, there were still 10 days left when it was lifted on the 1st of August. The second piece of legislation came in on the 1st of August. This is called the Residential Tenancies and Valuations Act. This is really to protect tenants who fall into rent arrears due to their income being affected by COVID-19. So there's quite a lot of information on our website about this this act, and it's worth probably going online and having a look at it, because this is really just a really quick synopsis of it. But basically, a tenant can self-declare that they're an eligible person for protections under this act, and that means that they can't be evicted from their tenancy or they can't have a rent review until early January 2021. There's also a provision in there that if the tenant is struggling with rent arrears, that they can ask us to link them in with MABs, and we can provide them with additional supports to help them to pay their rent. And there's certain steps for landlords to follow as well, and certain things the landlord has to comply with. And one of them, which is new really, is that when you're serving a warning notice for rent arrears, that you must issue it to the RTB as well as to the tenant, and the same when you serve the notice of termination for rent arrears, that it must be served on the RTB on the same day it's served in the tenants. So again, I'd really encourage people to go onto the website and have a look at this, because there's a lot more information on it, and like that there's a lot of steps for landlords to follow on this, and for tenants if they feel that they fall under the protections of the Act. And then the final one is the Residential Tenancies Act 2020, which came into effect on the 22nd of October. So this is very much applies to the travel restrictions that are in place in level 5. So it's very much tied to the 5-kilometre travel restriction. And again, it's, I suppose, to restrict people's movements around the place. So once we're in the level 5 travel restrictions, tenancies can't be ended during this period. There are exceptions to this, which are where there's tenancies where there's a notice of termination served for an antisocial behaviour, for unauthorised use of the dwelling, or where there's a threat to the fabric of the dwelling. So notice of termination can be served and acted upon for those issues, but any other issue, they can be served a notice of termination, but it won't come into play until this is lifted. So again, this is a pausing of notice of termination. So if you've served a notice of termination and it hasn't fully expired yet, it's paused from the date that this act came in, and it reinstates when it's lifted. Now there's also a 10-day grace period, so it's when the restrictions are lifted plus 10 days, and then the notice or the termination period starts up again. So just really quickly about dispute resolution services. So we have, I suppose, 2 main aspects to dispute resolution. So we've an awful lot of information on our website, I've already said, for self-resolution. If that doesn't work, we have telephone mediation, which is a really good, quick and easy way of getting a resolution once both parties agree to it. The mediator calls both parties and tries to find a solution to it, and the solution can be legally binding through determination order if needed. If you want a more formal hearing, we have the adjudication process. At the minute, since COVID came in, we've been doing these as paper-based adjudication. So you send in your evidence, both sides send it in, the adjudicator considers it and makes a decision on it. Then obviously for mediation and adjudication, if you're not happy about it, you can appeal it to a tribunal. And at the end of the process is a legally binding determination order. We are as well rolling out virtual hearings means that people don't have to travel for hearings or do face-to-face hearings. So we're rolling them out at the minute. And just that's a little bit of information about adjudication versus mediation. And there's a lot of information on our website about that as well. And like I said, there's the link to the website, which I've been really plugging, but definitely worth going to look at it. So I'll just stop sharing screen there.
Fantastic, Emer. That's brilliant. Thank you very much for that whistle stop tour to more than my own slides, because we're caught for time, and we could probably do an hour on each of the individual topics that we both covered. It's 5 to 1 now, so we might take 5 minutes really to run through some of the shorter Q&A questions, and I suspect a lot of them have been dealt with in your slides. In other words, they were coming in as we were going through the presentation. But the one that jumps out at me is, do REITs come under RTB regulations, tenancy registration, RTB dispute resolution?
Yeah, they do. So we see this where the rates are the landlord, where they're the owners of the properties and they're the ones leasing out. They'd still need to register the property, and if you have a dispute with it, then you would take it against that. You probably usually you'd have a contact person, an agent, and you can take any issue with dispute listing them as the landlord.
I think there's a sort of a tangentially related question. With the development of the enhanced lease with the local authorities, are these covered by the RTB as the landlord is the council?
I don't think so, no. If the landlord is the council, they don't come under the RTB.
Yeah, so we'll deal with that one. Another one, can Emer confirm RPZs don't apply to AHB tenancies? So the rent pressure zones.
Yeah, the AHB tenancies have a different way of formulating their rent. It's generally done as a percentage of income. So they do have their own way of doing that. So generally RPZs don't come under them if they're going by differential rent.
Okay, we had a few questions. Maybe I'll take some of the questions that came in earlier before we had the session. I think actually you dealt with a lot of those in the context of the emergency legislation, but there was a question there in relation to damage to a property and tenants versus landlords' responsibility for repairs, I think, and it was in relation to landlord obligations. So I think you covered a lot of that in your presentation earlier.
Yeah, there's a bit, I suppose there's a piece of a tenant should always report any kind of damages or anything that's maintenance issues or anything like that to the landlord. And then if the landlord doesn't address them within a reasonable amount of time, if they don't make any effort, then they can bring a case to us for breach of landlord obligations. And like I said about the minimum standards, if a tenant feels like the property isn't up to minimum standards, they can go to the local authority and report that, and they'll deal with that.
What happens, I see another one there, what happens when a tenant disputes a notice of termination with the RTB after 28 days of receipt of their notice?
In that case, if the tenant, I suppose, yeah, it states in the lease or in the notice of termination that it has to be brought to the RTB within 28 days, but often we see people may not do that and they'll bring a case later. So in those cases, it's brought before the board and the board look at the good grounds for the tenant, and then they make a decision whether the case can go ahead or not, depending on the good grounds.
There's a question in there that I might take. How many owners can go on a board of directors? Have they to be appointed at an AGM? So there's two questions there. How many owners can go on a board of directors? That'll be set out in the constitution of the owners management company. So have a look at your OMC constitution to deal with that. The second question then is, have they to be appointed at an AGM? Typically they are appointed at an AGM, but there is usually the facility to co-opt people during the year, during the time between general meetings. So if someone puts themselves forward after the AGM and says, I'd like to be a director, and if the other directors are happy with the individual, they can co-opt them, they can appoint them to the board, and then they can be duly elected at the next AGM. A question in there, just wondering what a reasonable time for repairs is. Where can I find this information? Probably on your website, Emer, would that be fair?
Yeah, I mean, a reasonable time for repairs, it really, like, it depends on the type of repair as well. Obviously, if there's a burst pipe and there's water gushing down into a kitchen or through a ceiling or something, that's a very urgent repair that needs to be done. So I think it is, like, we don't have laid out reasonable times, but I suppose it's really a bit of common sense. Like, if somebody can live in a property, if there's something that needs to be fixed, you need to get an electrician. If it's urgent, it needs to be dealt with quickly. So it's really about that using your sense of the person living there to work that out.
I see another question there. What rights do tenants living long-term in caravan parks have? Some unlicensed caravan parks are allowing people to live there permanently. That might be a planning matter, would it, for the local authority, and licensing matter for them, perhaps?
Yeah, often they don't come under our remit. It depends on, I suppose, how they're laid out, the caravan parks, but you know, you can go onto our website or go onto web chat if you're not sure and get an answer on that. Great.
Well, look, it's 1 o'clock, and we couldn't possibly get through all the questions that we've received. What we might do is say to people, there's a wealth of information on the RTB's website and your various web chats and telephone facilities, equally from the landlord-tenant relationship. Equally on our own website, there's a wealth of information around OMCs or where to find other information. I know, Emer, you're happy to take queries maybe by email to the usual contact points on your website. And then, of course, if people have particular disputes that they want to see resolved, there are processes, obviously, that you've outlined in your presentation that people need to follow. Again, I think what we'd say is the information we've delivered here today is signposts and general in nature for people. Specific cases require specific, I suppose, consideration, because every case is different and there are subtleties and nuances and ins and outs to it all. So we'd encourage people to take the routes that are set out there. What I might do is it's just after 1 o'clock, and I think we want to respect everyone's time, our attendees, our panelists, and everything else. So it falls to me perhaps to say, Emer, thank you very much for your time and the time of your colleagues, to Andrea, who is working away in the background, and to Karen Gallagher for her assistance in relation to organising this session, to my own colleagues, Tara Doyle, Sarah Kennedy, Michael McHale, and others who were working hard in the background. Thanks to all of you for attending. We had, I think, nearly 800 people at one particular point, so fantastically busy session. And apologies we couldn't get to all the questions in the time allowed. Emer, any closing remarks from your side?
No, I think I plugged the website heavily enough. So if you have any queries, just please go on there and check it out. Thanks. And thanks, David, for inviting us to take part in this. Great.
Look, thanks very much, everybody. We'll leave it there. We wish you to stay safe and mind yourselves in the current difficulties, and hope you're managing well. Thank you very much for attending, and we'll be in touch with a link to the recording and slides and so on. So thank you indeed.